Liberty Fighters Network.
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 Liberty Fighters Network. Liberty Fighters.
Good day, liberators and fellow South Africans. At last, I need to face the music. The National Prosecuting Authority of South Africa has summoned me to appear in court on the 19th of October 2022 at 8:30 in Court 19 at the Bloemfontein Magistrates Court to face charges of contempt of court brought against me by the state relating to a complaint by the Supreme Court of Appeal. And before I continue with this, I need to emphasize that I've already got about at least 5 constitutional defenses that I'm going to raise before we even get to the merits of this matter. So just follow me and through this case what they are and why. I'm looking forward to this prosecution. Really, I'm not scared. And in the same sense that even if I am found guilty, which would be a total travesty, I'm willing to accept my fate. But this is something that I need to go through. Many of our supporters have communicated with me, telling me, Reyno, just go and apologize. They will most probably withdraw the charges. Go and apologize. We need you. We need you to fight. And I'm just telling our supporters and the people of South Africa that thank you very much for your concern, but this is something that I must do. I've got a reason why I must go through this. Those of you who follow us diligently know that Liberty Fighters Network and I have been advocates and activists for the total reformation of our judicial system. And not only a transformation, there's a difference between the two. A reformation is literally changing the entire system, where a normal transformation is just making it more representative. That never, after so many years, 26 years of, in fact 28 years of democracy, we should have noted by now that a normal transformation of the bench is not adequate. We need to go in and change the judicial system physically. We need to do something about the way it operates. It's not accommodative to the man in the street. If you don't have the luxury of affording an extensive and expensive legal team, you are bound to fail in this judicial system. It's not made for you. It's not made for the man in the street, the people, you and I. Now, let me just quickly confirm before I go ahead and go to the claimed judgment, which have initiated this entire prosecution. I need to state that by referencing to this judgment and to this incident, I'm not giving up my rights as an accused in whatsoever nature. I'm merely referring to what is there and what have been widely publicized in the media and social media, and I'm not consenting to any of that to be used. What have been made public is not necessarily something that may have been made public. I just want to emphasize that. So let me go to the judgment, and just very much interesting here is that this judgment in the Supreme Court of Appeal, the matter was heard on the 26th of May 2021. Yet in paragraph 117 thereof, they refer to an alleged incident on the 18th of June 2021. So people, clearly this incident that the court is referring to in the judgment itself relates to an alleged incident which took place on the 18th of June, some almost a month after the hearing took place. Let me just show you something in their own claim judgment that you need to take note of when I'm referring to this. And if this is not hypocrisy to its extreme, I don't know what hypocrisy is. But let me show this to you in their own judgment. Now, they said in paragraph 28, they refer to the level 3 COVID-19 regulations that we were challenging the COVID-19 Disaster Management Act regulations then. They're referring to the fact that this broad formulation included and was intended to include within its scope the level 3 regulations, even though they were not dealt with in the affidavits and were not before the court when the case was argued. And then they go on to say in paragraph 82, relating to those very level 3 regulations, and which was eventually a reason why the appeal by the government was allegedly upheld, is that accordingly it was impermissible for the High Court to have considered and made a determination in respect of the level 3 regulations, which were not properly before the High Court. What is more, it arrived at its conclusion without affording the Minister an opportunity to be heard. The breach by the High Court of something so fundamental as the right to be heard taints the High Court's judgment. Okay, an incident that they're referring to, which were allegedly contemptuous, took place on the 18th of June, and they have actually mentioned it in their own claim judgment. Now, what is the difference between the level 3 not being before court and that the Minister did not have the opportunity to be heard, and myself? I obviously could not have been heard in terms of an incident that they are relying on the 18th of June, because the matter was heard on the 26th of May. So, and in this judgment, they have gone as far, and let me emphasize this, that in paragraph 119, they say, the last written communication from Mr. De Beer and the LFN is crude, graciously insulting, clearly contemptuous, and intended to denigrate this court. Okay. So the Supreme Court of Appeal, after having said that in their own claim judgment, that I was contemptuous, I was insulting, so they are saying that in their judgment, but I have not been afforded the opportunity to say anything or defend myself while they came to that conclusion, and now they have gone so far to tell the state to prosecute me in a magistrates court which is inferior to the Supreme Court of Appeal. So people, we are already sitting here with a massive constitutional crisis because, and let me explain. Number one, the state, National Prosecuting Authority, is prosecuting me for a complaint by the Supreme Court of Appeal. So it was never leveled, this incident that allegedly took place, at a officer, judicial officer, or a court officer. It was against the Supreme Court of Appeal. But then there's something like the separation of powers, which says that the state cannot interfere with a court, and they are separate. They need to be separated. So my first concern is that how can the state prosecute where the complainant is the court, and not only the court, it's the Supreme Court of Appeal in the Magistrates Court. Secondly, if they have already said in the Supreme Court of Appeal that I am contemptuous and I have not been afforded the opportunity to defend myself or to say anything in my defense, I was already then found guilty of contempt of court by merely a civil judgment in the Supreme Court of Appeal, and the Magistrates Court must then follow the ruling of the Supreme Court of Appeal. So even if I proceed with this contempt of court, defending it, the Magistrates Court will have to find me guilty already. I can just sit back and say that I cannot defend myself because you are obliged to follow the ruling of the Supreme Court of Appeal. And then thirdly, we've got to do with the issue surrounding, can the court sit as judge in its own cause, where the complainant is the court, and now the court, Magistrates Court, must be a judge in, while the complainant is the court itself. And then the other aspects are very interesting, which I'm not going to go into now. There are two others that I will highlight. Now, what is going to happen with this? This incident and this entire matter will have to be referred and come before the Constitutional Court. I am willing to take it to the Constitutional Court because the Constitutional Court must deal with this matter. And if procedures of the Supreme Court of Appeal are at stake here, the Constitutional Court is the only one who can actually, in fact, then legally and constitutionally prosecute me. But then we've got another problem because the Constitutional Court will then have to sit as a court of first and last instance, and the Constitution itself gives me the right as an accused to the right of appeal. And after the Constitutional Court, there is no option of appeal. So what is going to happen with this? Have I figuratively, I need to add this, the court with their pants down constitutionally, or is this the time now which they have agreed to needs to come up in public to start openly discussing the issues surrounding the total reformation of our court system. So if there's one thing that I am willing to sacrifice everything for, I know that my God and my family will always be there in support of me, so I'm not sacrificing them. But if there is anything that I need to sacrifice, this is something that I'm really able to do. If they really want to lock me up in Robben Island at the end of the day for allegedly committing contempt of court, and the entire situation has not been properly adjudicated, I've been literally found guilty before I even had the opportunity to state my case. What hypocrisy in the very judgment of the Supreme Court of Appeal to say that they cannot address something, or a court cannot address something that was not before it, and not afford the minister or a person the opportunity to defend himself and to be heard, which is a fundamental right according to what they've said themselves, but they're doing it to me. People, if this is a crusade against anyone who wants to reform the judicial system of South Africa, and we are faced by what I've already had to face in normal cases where the Supreme Court of Appeal is then used, claim judgment is used to interrogate me as a suitable person to be a representative. It now happened again in the Western Cape, whereby my own suitability to represent our own members before the Equality Court has been questioned by the court itself based on the judgment of the Supreme Court of Appeal, and regrettably, I never had the opportunity to defend myself in the Supreme Court of Appeals matter, and also in the recusal order that was in the Equality Court by a certain judge, who also used that very same judgment against me as the cause of her recusal. This is totally insane, and if this is justice, I am prepared to die for it, because our people needs to be liberated against the shackles of the judiciary as it is today. If there's no proper reformation of our judicial system, we are bound to fail our democracy. People, I just wanted to emphasize this, and I will obviously make other videos. Share this. Remember to subscribe to our channel. Consider joining us as a paying member as well, and share this. Ring the bell if you want to be notified in future. Until the next time, God bless all of you.
Liberty Fighters Network.
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 Liberty Fighters Network.